without debate, without criticism, no administration and no country can succeed and no republic can survive. Just imagine if in the same family there is one law for one member and another law for a second member. Will that household be able to function? Can a country with such dual system run? Good morning to one and all present over here. Today, I, Keshav Bhardwaj, a student of legal sciences, is going to put forward my views in favor of the motion that yes, the time has now arrived for the implementation of Uniform Civil Code in India. Dear listeners, in his book, A Plea for Uniform Law of Divorce, writer S.S. Nigam has jotted down that not much progress has so far been made in achieving the ideals of the Uniform Civil Code, which still remains a distant dream. The only tangible step that is taken in this direction has been the codification and secularization of the Hindu laws. The codification of the Muslim laws still remains a sensitive matter, although enlightened Muslim opinion appears to favor such a step. It is really very necessary that the law be divorced from the religion. With the enactment of the Uniform Civil Code, secularism in India will be strengthened, as much of the present day separation and divisiveness between different religious groups prevailing in the Indian society will ultimately come to an end, and India will emerge as a much more cohesive and integrated nation. The Supreme Court has also emphasized that the steps we initiated to enact the Uniform Civil Code as envisaged by Article 44 of the Indian Constitution. After reviewing a number of laws prevailing in the area of marriage in India, the court has, in the case of M.S. Jordan Dingdesh versus S.S. Chopra, held that the laws relating to marriage, adoption, inheritance, succession, judicial separation, etc. are far, far from uniform. And surely, the time has now come for a complete reform of the law of marriage and make one uniform law applicable to all the citizens of India, irrespective of their gender and caste. In this particular case, the court has quoted, "We suggest that the time has now come for the interference of the legislature in these matters to provide for a uniform code of marriage and divorce at least." In the case of Muhammad Ahmad Khan versus Shahabano Begum, Honorable Supreme Court of India has emphasized that a common civil code will help the cause of national integration by removing desperate loyalties to the laws having conflicting ideologies. The court also appreciates the difficulties involved in bringing persons of different faiths and persuasions on a common platform, but nevertheless, the court also emphasized that a beginning has to be made if the constitution is to have any meaning. It is the state which is charged with the duty of enforcing the Uniform Civil Code, and unquestionably, it has the legislative competence to do so. In the absence of such a civil code and the inaction of the legislatures to reform the personal laws, the role of the law reformers has to be assumed by the court itself, because it is beyond the endurance of the sensitive minds to allow injustice to be suffered when it is so palpable. For the kind information of all the listeners present over here, as per the historians, the origins of the Uniform Civil Code can be traced back to the Romans, who used to govern themselves based on a common civil code and not the holy text. The Mesopotamians did the same. They followed the code of Ur-Nammu, apparently the oldest law code in history, which encourages people to think of themselves as one single family with one set of rules and regulations. As the time passes by, many Islamic countries such as Pakistan, Turkey, Egypt, who were once governed by the Sharia law, had shifted themselves to govern their subject based on the common civil code. Under the principle of laicity, a citizen's first allegiance is towards the French society rather than to any group, be it political, social, religious, or otherwise. The Turkish laicity led to the banning of the headscarves many years before the ban was instated by France, and also led to secularization of the public education and suppression of the Islamic religious orders. After raising appropriate contention before the learned judges and listeners present over here, I would like to conclude my words by saying that if we are given an option to choose between Gita, Quran and Constitution, and if you take 10 seconds to choose Constitution, you are a sinner. And if I take 5 seconds to choose constitution, I am a greater sinner than you all. Jai Hind, Jai Bharat, Jai Vidhan, Jai Samvidhan.